Joining us today is Ashley, a trainee solicitor at Ravenscroft Schmierer, where she is building a specialized practice at the intersection of law and technology. Ashley first joined the firm as an intern, later becoming a part-time paralegal during her PCLL. With a science background from the University of Wisconsin-Madison and a JD from CUHK, she brings a unique, multidisciplinary approach to her work. She has been actively involved in groundbreaking digital asset litigation, including injunction orders in USDT recovery cases, while also handling transactional work for Web3 and corporate structures. She's here to share her insights on enforcing property rights in the virtual asset space and the evolving regulatory landscape. Ashley, welcome.
Hi everyone, I'm Ashley. Happy to be here. Thank you for having me.
Thank you for joining us. Your background combines science with law. What first drew you to focus on virtual assets and emerging tech like AI in your legal work?
I've always had a strong interest in virtual assets and AI, and I try to keep up with how the space is evolving. So when our litigation team started handling some of these cutting-edge cases, I was really excited to get involved. I learned a lot from my leader and colleagues, Anna, Joshua, Louis, and Christy. We are a good team.
That is a fantastic foundation. Sounds like you've had some great exposure through that team. For listeners who may not be familiar, could you walk us through how Hong Kong courts currently treat virtual assets, just to give us some context before we go deeper into the legal tools?
Yes. So I believe the first virtual assets case was 6 years ago. It was an English case, namely AA and persons unknown regarding Bitcoin. Hong Kong adopted the rationale later.
Interesting. Was the recognition easy?
I won't say it's too hard. The four features of property are identifiability, assignability, stability, and enforceability. Virtual assets like crypto or NFTs, which is non-fungible tokens, actually fits this quite well. It wasn't a huge stretch legally. It's more like applying old principles to a new asset class.
That's a crucial point about applying established principles. In practical terms, what does this mean for an individual or company trying to prove that they own a specific NFT or token in a dispute?
Recognizing virtual assets as property in Hong Kong is a game changer for owners of tokens or NFTs. Practically, it means you have a lot more legal tools to protect and recover your assets.
Would you be able to elaborate on that? Perhaps you can give us an example of those legal tools?
Okay, sure. For instance, if your crypto or NFT is stolen, you can ask a court for a proprietary injunction, basically a court order to freeze those specific assets. It just as you would for stolen tangible property or funds in a bank account. It also means you can assert ownership rights in court and even trace the assets if they've been transferred, since the law views them as property that can be followed.
And what about the impact for companies specifically?
For companies, this recognition allows digital assets to be held on trust or on balance sheets with clear legal status. In short, treating crypto as property gives victims of theft or fraud a clear pathway to claim that token is mine and get legal remedies like freezing orders or recovery orders that simply weren't sure bets before. It provides much needed clarity and protection in disputes over digital assets.
What kind of evidence, beyond just controlling a private key, is becoming crucial in court to proving ownership and control over a digital asset?
Courts are looking for a broader evidence picture these days. control of the private key alone isn't always enough. For example, a hacker might control your key, but obviously isn't the legitimate owner.
That makes sense. So what constitutes this broader evidence picture?
So we bring in blockchain forensic evidence and contextual proof. This can include transaction histories like link wallet to a particular individual or entity, say showing that a wallet was funded from a non-exchange account in the person's name. We also use records from crypto exchanges or platforms. If someone bought an NFT on a marketplace, there might be receipts or profile info tying that asset to them.
What about more traditional forms of evidence?
Even communications can matter. I've seen cases where chat logs or email confirm an agreement about who owns a token. Essentially, any evidence that creates a narrative of true ownership, such as purchase records, exchange KYC data, expert tracing analysis, can be decisive. Even communications can matter. I've seen cases where chat logs or emails confirm agreement about who owns a token. Essentially, any evidence that creates a narrative of true ownership, such as purchase records, exchange KYC data, expert tracing analysis, can be decisive. It's about how the asset in question really belongs to your client, beyond just the say, I have the key, trust me.
Hong Kong has recently implemented both the VASP licensing regime and the new Stablecoin Ordinance. From your research and advisory work, what do you see as the most challenging compliance requirement for firms operating under these new rules?
I think one of the most demanding compliance requirements we've seen is the anti-money laundering, also known as AML, and the travel rule obligations under these new regimes.
The travel rule is often cited as being particularly tricky. So what is it exactly that makes the travel rule so challenging?
For example, the Hong Kong rules now expect virtual asset service providers and stablecoin issuers to attach detailed sender and recipient information to every transaction, no matter how small. Implementing that travel rule compliance with zero threshold is technically complex and resource intensive, so firms need new systems across the industry to make it work.
And for stablecoin issuers specifically?
For stablecoin issuers, they are required to maintain fully backed reserves and regular audit under the Stablecoin Ordinance, which can be a heavy lift as well.
With all these requirements, if you were allowed to pick just one, which one is the most challenging requirement?
If I had to pick one, definitely the AML controls, especially the new data sharing requirements for transactions. One of the original appeals of virtual assets for many users was the ability to transact pseudonymously, or at least with more privacy than traditional finance. And this makes KYC AML much harder in practice. Some users push back, others move to unregulated platforms, and the legitimate firms are caught in the middle. The compliance burden, both technical and operational, ends up being very high, especially for smaller players trying to build in Hong Kong under the new rules.
Speaking of this, our firm's work on the worldwide A+ limited and anonymous wallet holder case was groundbreaking, using a tokenized injunction. From your experience, what were the biggest practical and procedural hurdles in getting a court to approve an injunction against a pseudonymous wallet address rather than a known person?
So normally, you deliver court orders to a person or a company at a known address. Here, we were dealing with just a blockchain wallet address with no name or physical location.
That's a fundamental procedural obstacle. So how did you solve the problem of notification?
We had to persuade the judge that posting the injunction directly on the blockchain, effectively attaching a notice to the wallet itself, was actually a valid way to notify the unknown owner.
That's such a fascinating workaround. So you're saying the wallet itself became the place of service?
Exactly. Another challenge was getting the court comfortable with the idea that it has jurisdiction to bind a pseudonymous party. We argued that whoever is behind that wallet is subject to the order once notified, and that this was necessary to prevent the digital assets from vanishing. It helped that we could demonstrate this approach had teeth. By recording the injunction on-chain, anyone interacting with that wallet would see it.
And I imagine courts aren't exactly used to thinking in terms of blockchain native remedies. How did the court react to such a novel idea?
So the newness of using blockchain as an enforcement tool required us to educate the court on how it works and assure them that this wasn't violating due process. In the end, the uniqueness of the situation and the risk of irreparable harm if we did nothing made the case for an unprecedented solution. But getting there involved addressing a lot of first-time ever questions in the courtroom.
Once such an innovative court order is granted, what does the enforcement process actually look like? How do you ensure that a freeze on a blockchain is recognized and respected by exchanges and other network participants?
After obtaining the order, the execution becomes a blend of tech and legal process. The tokenized injunction was literally recorded on the blockchain. In our case, we attached a kind of digital notice to the wallet address in question. This had been described as akin to stamping a dollar bill with stolen. Anyone checking that address can see there's a court order freezing those assets.
That's the concept, but how is it done technically?
In practical terms, we accomplished this by publishing the injunctions details to the blockchain, for example, via a smart contract or a token with the court order embedded in its metadata sent to the address. That covers the on-chain transparency.
And how does this translate to real-world enforcement?
This act will notify major exchanges and stablecoin issuers about the freeze, so they are legally on notice that the assets at that address are tied up by the court. Exchanges and issuers don't want to facilitate a breach of a court order or handle potentially tainted funds.
So the freeze is enforced by the ecosystem itself?
In some other cases, as to my knowledge, the issuer of a token, like a stablecoin company, can freeze those tokens directly on their end once they know about the order. So between the public blockchain notice and the direct coordination with key players, such as exchange token issuers, the freeze becomes effective. It is not enforced by some police squad of the blockchain, but rather by creating a situation where no reputable actor will touch the assets, and any attempt to move them is immediately visible and legally risky.
You've walked us through those fascinating and practical details of enforcement. Today's conversation has demonstrated that Hong Kong's legal approach to virtual assets is dynamic and proactive, evolving from foundational property rights to cutting-edge enforcement mechanisms like the tokenized injunction. As the region builds its framework for a digital asset hub, it's becoming clear that sustainable growth requires this dual commitment to both technological and legal innovation. Thank you, Ashley.
Thank you for having me, Jasmine. It's been great sharing some of what we've learned through these cases.